Welcome. Good morning or good afternoon or good midday. I am Sue Raymond. I'm Director of Brandeis University Press, and on behalf of the Lurie Institute for Disability Policy at Brandeis, the International Center for Ethics, Justice and Public Life, the Legal Studies Department and Brandeis University Press, welcome. Welcome to a book launch and discussion of the new book, Pain and Shock in America, Politics, Advocacy, and the Controversial Treatment of People with Disabilities by Jan Nisbet, which was published last week on the 8th of October. And this is the first event we are having to celebrate the launch of this book. And I just want to say how proud I am at Brandeis University Press to be publishing this book. It is an excellent and accessible account of the history of the Judge Rotenberg Center, and it's an important addition both to Brandeis University and Brandeis University Press's mission to promote social justice. Jan Nisbet is Professor Emerita at the University of New Hampshire, where she served for 10 years as Senior Vice President for Research. Before then, she was the founding director of the Institute on Disability and professor in the Department of Education. She has been principal investigator on many state and nationally funded projects related to children and adults with disabilities. She collaborated with Nancy Weiss on this book, and Nancy is a faculty member and the director of the National Leadership Consortium of Developmental Disabilities at the University of Delaware, and an advocate against the use of aversives at the Judge Rotenberg Center. And you'll meet Nancy and see her later as a panelist. This meeting will take the form of an interview between Jan Nisbet and Ari Neeman, and then we'll open up into a panel discussion moderated by Ari. And one note, if you would like to purchase a copy of the book, please do so from our website, which is brandeisuniversitypress.com, and the URL is in the chat. The book won't be available on Amazon until the beginning of November, so we are offering it today and tomorrow for people who are attending this program at 20% off with the discount code PAS20, and that will be in the chat. It is now my pleasure to introduce Ros Cabral, who is the chair of the Legal Studies Department at Brandeis. She is the editor of the Brandeis series in Law and Society, and she's also a practicing lawyer. And this book is the first title to appear in the new book series, the Brandeis series of Law and Society. So over to Ros.
Thank you so much, Sue, and thank you for Jan for being here today, and for our esteemed panelists, and Ari, thank you so much for moderating this discussion. As Sue mentioned, I'm the chair of the Legal Studies program and one of the editors of the Brandeis series in Law and Society. Through this series, we aim to shed critical light on the variety of ways in which legal rules and the institutions that enforce them affect our lives. I'm incredibly proud that this is the first book in our series. As I mentioned before we began, I've been following the litigation involving the Judge Rotenberg Center since I became an attorney, practicing in the Commonwealth in 1999. And this story needed to be told in this incredibly well-researched and comprehensive way. So thank you for your painstaking work on this project. Would like to also thank the esteemed panelists for joining this event as well. Thank you for your wisdom and expertise that you're sharing with us today. And welcome to especially my students who are here to learn from you. Finally, we learn most about law and society from the personal stories involved in of people involved in controversies. This book starts with a story, and they're woven throughout in the text in a way that makes this long and controversial topic accessible to everyone. So thank you. And I'd like to turn it over to Ari Neeman, who is the visiting scholar at the Lurie Institute for Disability Policy and co-founder of the Autistic Self-Advocacy Network. Ari, thank you for moderating this discussion.
Thank you so much. And let me begin by thanking Jan for an extraordinary and I think very timely book that rewards both reading for research and for narrative. I think this is really a very important topic, not just because of what happened and what is still happening at the Judge Rotenberg Center, but also because of what the decades-long process of working to close the Judge Rotenberg Center or working to stop the use of contingent electric shock says about our society and its failures to guarantee the fundamental rights of people with disabilities. I want to preface this discussion by saying we're going to take a somewhat unusual format here. Jan and I are going to talk, and Jan, I've got some interesting questions for you where I'm hoping you will shed light on some of your motivations in this book and some of the broader scope of thinking in your advocacy work. But then we're in, I think, for a real treat because Jan has selected a number of excerpts from her book that she will be reading, interspersed with our Q&A discussion today. So you'll both get to hear Jan and I talk, but more importantly, you'll get to hear small portions from Jan's exceptional book. So with that, I want to begin, Jan, by asking you if you can speak a little bit about the issue of morality and the other when it comes to a topic like this. Because one of the consistent themes in reading your book is a sense that the Judge Rotenberg Center and many of the defenders of the Judge Rotenberg Center really placed people with disabilities in a realm devoid of the same legal, but also moral and ethical protections that people without disabilities are able to take for granted. And I'm just curious, in your exploration of this topic, where does that othering come from? Where does the ability to look at people with disabilities as a class to which basic considerations of not just human rights, but human decency do not apply?
Well, Ari, I'm not surprised that you asked me the existential question first. So I will do my best. Before I start, I just want to thank the folks at the Lurie Institute and Sue Berger Raymond in particular for publishing this book. I thought it was going to be a hard sell, frankly, and she immediately saw the importance of the topic and really worked very closely with Nancy and I to get this book done in a timely fashion. So I just want to thank everybody and thank you, Ari, for that great question and for moderating this session. So when I started this book, I didn't start it with this idea of othering and so much. I mean, I had the big question, which is, how can this be? How can this be in America? And it certainly goes against my moral code. And I attempted to figure out how it is as a society that we allow interventions that aren't allowed on animals, on people, and in particular, people with disabilities. And when I was engaged in a lot of conversations, many of the conversations targeted individuals. So it was the attorney, it was the judge, it was the center, it was the legislator, and individuals were to blame. And as I spent a lot of time reading documents and getting, saddened often, I would say, it became clear to me that yes, there were all these individuals involved and families and people with disabilities and lawyers and judges and state bureaucrats. But the big picture that I walked away with is that somehow, and I don't have the answer to this, somehow the people who ended up at Judge Rotenberg, and I think other places in the country with less than adequate supports and services, or somehow seem as though they are different and lesser and less human. And how does that happen? And I don't have the answer to that, but I do I do firmly believe, and I shared this with you, is that there were always arguments between professionals. One professional loved it, another professional didn't love it, right? Hated it, thought it was immoral. One set of families, had deeply believed in it. It's the only thing that saved my child's life. And I don't want to minimize that, because I believe they believed it. And then another set of families that were either horrified at the thought of it or had horrible experiences. But as I see the world changing, I really believe it is the voice of self-advocates that has made the difference. And I think it's the voice of self-advocates that is deconstructing othering. Because now I think it's no longer an argument between just professionals or families, because I have never met a person who is a self-advocate who says, I think electric shock is a good idea. And I believe it's the emergence of this voice that made the difference with the FDA in its decision to ban electrical stimulation devices. And I think it will continue to make the difference going forward. I don't know if that answered your question, Ari.
I think it's very powerful. I'm intrigued by this point that you make regarding the nature of the self-advocacy movement as a indispensable stakeholder here. It sounds like what you're alluding to is when policymakers hear parent versus parent or provider versus provider, they just throw up their hands. They don't know what to make of it. But the self-advocacy movement, despite in some ways having fewer resources than other stakeholders in the disability community, has this greater moral authority that can tip the balance. Is that more or less what you're alluding to?
Absolutely. And I mean, I'll allude to your testimony in front of the FDA, Ari, which I thought was incredibly powerful, where, you said it could have been me. And it only wasn't me because of my family. And for people to hear that from you is so much, I think, more powerful than hearing two sets of scientists argue about efficacy.
I remember being in the room saying that at the FDA hearing, and I remember, frankly, being very uncomfortable, talking about myself. I hate talking about myself. I find that when you talk about yourself as a person with a disability, people don't want to hear about anything else. But I remember feeling that there was just this obligation to say those words and to acknowledge that, because you and I have both met people who have been in Judge Rotenberg Center, and while the JRC wants to present them as the most disabled people in the country, not that what they do would be acceptable for the most disabled people in the country, but that's the image they want to present. The reality is that there are a great many people within the JRC who have similar disability profiles to myself and some of the other folks you're going to hear from today. But the thing that I find really powerful in your advocacy, Jan, not just in your book, is that absolute commitment to equality, regardless of level of impairment. And I just really applaud you for that. And I can't thank you enough for your long history of leadership in this space.
Thank you.
So this seems like a good segue. I think this is an opportunity for Jan to read a small passage from her spectacular book. And without further ado, Jan, I'll hand it over to you. And then after that, we'll come back to our discussion.
Okay. So let me provide just a little bit of context for everybody. When I began writing this book, I didn't know what I was going to find. I knew it was an important issue. I began looking in a very traditional way at documents, like, how am I going to get documents? How am I going to really understand the nature of the story? And when people began to know that I was writing this book, I began to receive boxes in the mail. Sometimes they had return addresses. Sometimes they didn't. Often they smelled very musty, which made me believe they were sitting in garages or basements or attracting dust. But within those boxes were some really amazing materials that people had copied, collected. I didn't use all of them. I couldn't verify all of them, but I used many of them in the book. And so I'll start with a story that is the result of a report that appeared in a box. On the night of October 19th, 1976, 2 children were playing in the parking lot of the old St. Anthony's School in Providence, Rhode Island. They happened to look in a basement window, then rushed home and told their parents that they saw a man being beaten in the church basement. The parents immediately contacted the police. The Providence Police Department report stated the children had observed through a window in the basement in the building a white male juvenile handcuffed to a chair in gym shorts, being beaten by several adults to the degree that it was leaving red marks. At this time, the police went to the window and observed exactly the same treatment to apparently the same child. The building was leased to the Behavior Research Institute. The police report continued. At this time, we gained entrance to the building by the serviceman and went to the basement room where the same 2 subjects were removing restraints from a male juvenile who appeared to be 14 or 15 years old. We then spoke to James Nussi and Vera DeMarco, who stated that they had written permission from the parents of these children to use physical restraints and slaps. They then showed us 2 typewritten letters signed by people who claimed were the parents of this child. The letter stated that the center had permission to use physical restraints and also to strike the child on his bare legs and also his buttocks. One of the students being restrained was William McVeigh, age 19, who had been at the Behavior Research Institute for less than 2 weeks. Matthew Israel, founder and director of the center, told police that William was getting treatment because he had attacked adult men without cause and pulled their hair and it came out, and the student's parents had signed a waiver that allowed this treatment. The other student being restrained was a 14-year-old Maryland girl who had been placed by the state because she had scratched off part of her nose. She wore a plastic guard to prevent her from gouging off the rest of it. 2 detectives spoke to Israel, reviewed the consent forms the parents had signed that permitted punishment and restraints, and then toured the facility. A detective concluded in the report, "I did not think it was necessary to bring anyone into the office for investigation. Dr. Israel was more than cooperative with the investigation. He called one of his workers in from home so that we could talk to her, and he was open about the activities and did not deny the fact that these incidents took place. He further stated that this is a relatively new concept in treating students, and there are pros and cons on the subject." Walker and Rishi concluded that BRI required no further investigation. They could not have predicted the subsequent deaths, investigations, lawsuits, complaints, news stories, advocacy efforts, legislative bills, tax dollars, and state regulations that would involve the BRI over the next 40 years. 2 years later, William McVeigh's mother removed him from BRI and explained why in a letter to Israel. "While we are grateful to you for the positive changes your program has made, Billy's most urgent need and primary purpose for attending BRI remains unresolved. Hopefully someday, just as it appeared in adolescence, it will leave him as he matures. In the meantime, we will continue to seek ways to cope. We feel Billy's basic personality is a beautiful one, and we don't want to jeopardize that in the process of changing one negative behavior, dangerous as it might be. While we feel that for Billy and others like him, behavior modification is a most useful tool for habilitation, we question the inflexibility of it as it was practiced in Billy's program. We felt the second order change was certainly very long overdue when the aversives had no measurable effects, even in the severity that they were practiced in this case."
So I think that's a very powerful passage. And I think it raises very interesting questions about what role behavior modification techniques, aversive and otherwise, play in institutional settings like the Judge Rotenberg Center. And I wonder if I might highlight just a particular quote in your book that I found really impactful. On page 24, you put in a quote from E.M. Opton. I want to just preface the question by reading this quote to you, because I think it really captures something. The language of behavior modification is ideally suited to this defensive operation, for it is abstract enough to include, yet disguise, any exertion of institutional power through reward and punishment. The language is useful in distracting the public, the legislature, the judiciary, and perhaps occasionally the inmates. But most of all, the language of behavior modification is marvelously suited to soothe the consciences of institutional administrators. Talk to me about the consciences of the people who have been defending the Judge Rotenberg Center and administering these techniques for all these years. Do you feel like there's a relationship between this paradigm of behavior modification, this paradigm of medicalization, and the ability to do these things?
I think they're all, I mean, in my opinion, they're all connected. And, you know, I have to say that I have met people who have been administrators of institutions. I describe certainly an individual, Albert Bascotti, who had people who had been at the Judge Rotenberg Center who did not use any of these, what I would call punitive techniques. And so I wouldn't say universally that like people are immoral. I think people make choices along the way about what it is they're able to do ethically. And I think there's some people that would argue that they feel a responsibility to offer high quality services to people and institutions. I also know that there are people that think it's impossible to offer high quality services to people and institutions by the nature of their environment. Institutions are restrictive. Behavior modification, it can be and often is similarly restrictive and coercive. I mean, other people, you know, people will argue that we live in a society, you know, Murray Sidman, we live in a coercive society. If you don't do that, I'm going to do this. If you don't eat your dinner, you can't do this. And many of the things that we have incorporated into our lexicon are, fortunately or unfortunately, you know, principles of behavior modification, reinforcement, punishment. It's how they are used and how coercive they are. And what they're trying to do that I think is most important, which is if they're trying to change an individual, if they're trying to make an individual be someone they're not, if they're trying to normalize that person, if they're looking through the lens of ableism, then I think we begin to approach a morality problem, which is one person insisting that another person becomes someone different than who they are. And that I go back to how important the self-advocacy movement is, how important communication is, how important choice is, and giving people choices along the way. And ultimately, how important it is to have a broad-based community infrastructure that's supportive and inclusive, so people aren't forced to make choices like institutions, for example.
So I think that's a very powerful point. Just continuing in the theme of morality, I want to take note of something else that you explored in your book. I was really shocked to discover that many of the most prominent opponents of the Judge Rotenberg Center, Harvey Lapin, Ann Donnellan, many others, played a role in bringing it to California. and then later, reconsidered. And, when they saw what was going on, they became its strongest opponents. And you saw these conflicts in California, the JRC, or then the Brain Research Institute, BRI, going after J. Nolan Center's fundraising telethon, claiming the J. Nolan Center didn't serve those with severe autism, very similar framing to some of the conversations we see about neurodiversity and autistic self-advocacy today. You really just saw a situation where you had folks who started out very open to the BRI's ideas, and as they were exposed to them and were exposed to the consequences, really totally changed their mind. So I guess one question I have for you, if you have some thoughts, is that what leads someone to not take that step, to not make that conceptual leap, to either remain quiet or continue to remain a supporter of these methods? What's the difference between an Ann Donnellan or a Harvey Lapin on one side and the many, many people who have collaborated with BRI or JRC over the years or remained quiet in order to avoid controversy?
Existential question number 2.
We're throwing you some really easy ones here.
Yes. What makes us who we are and what we believe. It's your background, it's your training, it's your peers, it's your experience with people with disabilities. I feel like I'm not qualified to answer, the question of why some people sort of choose to admit that they were wrong. I mean, Brian Awada, who I write about in the book, who was involved in the development of the self-injurious behavior inhibiting system, he ended up at the FDA hearing saying this was no longer necessary. We didn't need to use electric shock on people with disabilities. There are other people, who have been involved in these practices that haven't publicly testified. I can't say, Ari, why I know why they haven't come forward. And as you and I discussed earlier, there hasn't been a call for people that have been supportive of, electrical, the use of electric shock on people with disabilities, to come forward and to admit they were wrong. And some simply naturally do. And I can't answer why some people don't. I can say honestly that I had a very good academic training program, very focused on deinstitutionalization, desegregation, positive public policy. Not everybody has that. And they don't live it, and they don't necessarily have what I would call, rich relationships with people with disabilities, and I think may get into this sort of othering mode.
I think that's a good segue to our next excerpt. So Jan, take it away.
So this is an excerpt about shock therapy. And again, just a little bit of context. I met Gunnar Dibwad when I was an assistant professor at Syracuse University. And Gunnar would fly to Syracuse and teach a course. And so I got to know him a little bit while I was at Syracuse. And I knew that he was a very famous person and principled, and he and I had gotten into some pretty interesting discussions. At one point, he told me that he thought I was too clinical. And I had to spend a lot of time reflecting on that. But he was broadly respected internationally and kind of a go-to person in Massachusetts around these issues of morality and electric shock. So this is the marketing of shock therapy. Between 1985 and 1987, as BRI squared off with the Massachusetts Office of Children and the California Department of Social Welfare, the Applied Physics Laboratory, affiliated with Johns Hopkins University, was designing a device that would deliver contingent shock to people with disabilities engaged in self-injurious behavior, such as headbanging. The Applied Physics Laboratory was established in 1942 during World War II to advance engineering and science. Best known as a defense contractor and for developing advanced missile systems, it is well known for its work with sensors and signal devices, which were used in the design of Cybus, considered novel and technologically efficient. The Cybus provided the prototype for the other devices that BRI would develop that delivered more intense electric shock. Barbara Cutler, who many of you know, parent of a son with autism, a woman some describe as the unofficial ombudsman for disability services in Massachusetts, sounded the alarm about this new electric shock device. In May 1987, toward the end of the BRI Office for Children dispute, she sent a letter expressing her fears about the new device to Gunnar Dibwad, professor emeritus at the Heller School at Brandeis University. Born in Leipzig, Germany, he moved to the US in 1935. Dibwad and his wife, Rosemary, were leaders in the field for their work on deinstitutionalization and international disabilities rights movement. At different points in his career, Gunnar served as a supervisor of the Child Welfare Program of the Michigan State Department of Social Welfare, the executive director of the Child Study Association of America, the executive director of the Association for Retarded Citizens. While at Brandeis, he was the lead expert in the famous Penhurst State School and Hospital versus Haldeman deinstitutionalization lawsuit, which focused on ensuring that people with disabilities at state-operated institution in Pennsylvania had opportunities for community living. He also served on the Massachusetts Department of Mental Retardation Human Rights Committee. Gunnar and Rosemary helped to form the International League of Societies for Persons with Mental Handicap, which later became Inclusion International. He viewed disability as a civil rights issue, not a medical one. Some have referred to him as the grandfather of self-advocacy. He was opposed to the use of pain as a component of treatment or therapy and was outspoken in his opposition to BRI. Cutler wrote to him, "I am writing this letter to alert you to a serious and dangerous development in the area of treatment of persons with disabilities. Computerized electroshock headbands being ready for sale in the near future." On May 8th, Brian Awada, PhD of the University of Florida and formerly of the Johns Hopkins School of Medicine, presented a workshop on self-injurious behavior in Framingham, Massachusetts, to an audience of 50 to 60 people from both institutional and various community programs. During the last hour of the workshop, after some very heavy viewing of people who were injuring themselves, Dr. Awada presented a new procedure, which he called electrical stimulation. He described an electric headband that could deliver different schedules of shock in 0.5 second 9-volt bursts and be programmed both to respond with shock to certain movements and to collect data. He said that this device would meet the criteria of effective punishment because it would be A, intense, B, immediate, C, inescapable, and D, discriminable, his ordering of the criteria. Furthermore, it would eliminate the slippage caused by staff using aversives because it was a mechanical device and therefore more reliable. Dr. Awada went on to tell us that this device, which is being perfected at the Johns Hopkins Applied Physics Laboratory, is not experimental, that it had been approved for use and that it is being prepared for marketing. He added that the firm that will market this device, Marvel, in Dr. Cutler's words, is such a responsible company that it will sell these items only when they have been prescribed by physicians and other professionals. Of course, the device can be developed for any part of the person's body, and it is even now being developed at 2 levels of voltage. The device is activated by movement within a circumscribed electron field. Dr. Awada regretted that we in the field had been insensitive to our use of terms and products, i.e. we have used cattle prods and dog shockers. Now we have a device that is designed for people. The commercial name was not disclosed. The last hour was the most chilling presentation I have ever heard. The ramifications of this device are devastating, and Dr. Awada seemed either ignorant of those ramifications or indifferent to them. Is there anything we can do to prevent the distribution and use of this dangerous device? In my interview with Dibwad, toward very close to his death in 2000, in preparation for writing this book, he told me, Cybus is one of the most terrifying devices ever invented. It is not only harmful to people, it is harmful to society.
One of the things that I'll always remember about my own time fighting the Judge Rotenberg Center, which of course is one very small portion of the time spent, by people like Ann Donnellan and Tom Nerney and Barbara Cutler and many others over many decades. But this particular moment in time that will always stick with me is sitting in a meeting with the FDA. It was one of the early meetings we had with the FDA. I think Nancy Weiss was there as well. And one of the FDA case officers asking, have you ever thought about doing a randomized controlled trial and randomly assigning some children to positive measures and other children to contingent electric shock? And of course, I'm familiar with research methodology. I know why he was asking that, but it seems to capture this as really fundamental disconnect from basic ideas of morality, and fit within this theme that you're raising of disabled people as the other. So I think you have actually an excerpt that speaks to that, and I'll hand it over to you to read that. But before we do that, do you have any thoughts on that theme of the emphasis on scientific rigor to the exclusion of all consideration of values or morality?
Well, I wonder who you were talking to. I'm hoping that it was someone who, wasn't well trained. There's been enough atrocities and immoralities in scientific research involving, obviously African Americans, people, poverty. I mean, Hopkins, as you may know, had a large-scale community study that involved children living in poverty and exposure to lead that was very controversial. And so there's lots of examples that exist out there that I hope that we as human beings learn from, that, you have to now have ethical training when you're involved in a PhD program, and these issues, around causing pain to people, and human subjects committees, are very, if done well, that mean they would never allow you to do a randomized control experiment on people where one's subjected to pain and one isn't, at least now. I'm not saying that was always the case. So I hope that there's progress, in the field, and that we are not allowing those kinds of conversations to even happen. So it's 12:40, so we have 5 more minutes. Is that right?
That's right. I thought you would read this excerpt and then maybe you make some concluding remarks before we move to our panel.
So Ari, the other one that I shared with you was related, again, context, and I think it's related to this question that you have of randomized clinical trials.
Sure. It's your book. You should read whatever excerpt you want to close with.
No, but I just want to give people context of how it's related to this question around randomized clinical trials. So after the Office for Children decision, so this was the first decision by Judge Rotenberg that actually levied it required the state to pay legal fees. Essentially, it was a civil case that was brought against the commissioner, Mary Kay Leonard. The judge said that if the state didn't pay the legal fees, she would have to be responsible herself. And so this was and she was trying after Vincent Militek's death, frankly, to stop the use of aversives. So a person coming into a position, she was a trained attorney. And so this decision was obviously very troubling. And so people had this immediate reaction, which is, well, if the National Institutes of Health get involved, then, and if they say punishment is bad, then maybe we can stop it. And so this is an excerpt about what happened after that decision and what sort of going into the National Institutes of Health. So Judge Rotenberg's decision against Mary Kay Leonard and the Office for Children stunned anti-aversive advocates who struggled to understand the rationale for the decision favoring BRI and its potential impact. Judge Rotenberg dismissed the $15 million in damages requested by BRI's attorneys, but did not blunt the ramifications of his decision. He ordered the state to pay BRI's and the parents' attorney fees if the state refused. Mary Kay Leonard would be held personally responsible. So Red Turnbull, who and his wife Anne, who are at the Beach Center, wrote to Madeline Will after the decision. And in the letter to Madeline Will, and I think it's important, he says, what the decision does not decide is as important as what it does decide. It does not give blanket approval to use aversive interventions, does not establish low procedural safeguard obstacles, does not declare that the use of aversives is illegal under state statutes, or most importantly, under constitutional doctrines. The case turned on the application of state regulations. It did not involve state statutes. Apparently, they were not at issue, or constitutional doctrines. Apparently, they weren't even raised. It cannot be cited as precedent because it's a settlement agreement and not a consent decree. More, it is certainly not a decision that is the result of a fully litigated case, one where the parties were not agreeable to settlement and where they took the case to the appeals court. Clearly, this is not a good result as we wanted, but still not a disaster. Media, the Boston Globe in 2020, for example, portrayed it as a BRI victory, and in part, and maybe in large part, it was, because it will have a financial effect on the state and on the individual defendant, and probably will have a chilling effect on the state and any other individual's willingness to take on BRI. If Massachusetts fails to do so, Mary Kay Leonard would be held personally responsible. The main power of the settlement agreement is political. Its legal power is not so great. The open opportunities are at the point when the court must decide on a case-by-case basis whether the settlement agreement terms about the least restrictive alternatives and aversives and consent have been met. And who, after all this fight and in light of the council fee bill of $580,000, will be willing to fight? So he outlined the decision which Madeline Will then helped advocate for the NIH to get involved. The outcome of the NIH's involvement, you should read the book, was less than satisfactory.
So before we move on to our panel, do you have any concluding remarks and any concluding words you want to leave people with as the author of this extraordinary work?
I hope you read the book. I hope that it gets used in classrooms for students. And I hope that people who are interested and have their hearts in social justice also read the book, and that it stands up in time. So I want to thank everybody. Thank you, Ari. Those are great questions. I'll be thinking about them for a long time.
Well, thank you. Thank you. All right, well, without further ado, then we're going to move to our esteemed panel. I have the privilege of having known each of these panelists for a very long time. So I'm gonna read off their bios now, but I can assure you that these bios only capture the smallest portion of the wisdom and character that each of them bring into this discussion, as you will soon see. Jennifer Mathis is Director of Policy and Advocacy at the Bazelon Center for Mental Health Law, a national nonprofit legal advocacy organization that advances the rights of people with mental disabilities. Jennifer's work focuses primarily on the Americans with Disabilities Act and the Medicaid rights of adults and children with disabilities. Nancy Weiss is a faculty member and, until her recent retirement, director of the National Leadership Consortium on Developmental Disabilities at the University of Delaware. Ms. Weiss is the former executive director of CASH, an international advocacy association committed to the full inclusion of people with disabilities. Ms. Weiss has worked relentlessly to end the use of aversive procedures, and for nearly 3 decades, she has organized advocates and spearheaded efforts to eliminate the use of pain, coercion, and restraint as methods of behavioral control. And I'll interject here that if you read the book, you will see how central Nancy Weiss has been to these issues for a very, very long time. The great debt of gratitude we all owe her for her leadership. Finn Gardiner is the Laurie Institute's communications specialist. His research and advocacy interests include education and employment for autistic adults, accessible communications, and policy that takes into account the intersections between disability, race, class, and other experiences. He holds a Master of Public Policy degree from the Heller School. All right, so let's kick things off. So let me just begin by asking our panelists, how did you first hear of the Judge Rotenberg Center? And what do you think the Judge Rotenberg Center's existence says about the way in which our society approaches disabled people?
I'll jump in. It's Nancy Weiss. I first visited the Judge Rotenberg Center back in 1992 and left there, spent a couple of days there as a consultant to help the state of Delaware to bring back people from Delaware who had been placed there and in other out-of-state placements. I left there after a couple of days, just a changed human being. It was before the time of electric shock being widely used, but there were other simply horrible, frightening techniques used to control people's behaviors, and as worrisome, to control behaviors that were not dangerous, to control behaviors like getting out of your seat or taking your eyes off your work or making noises under your breath, or any number of things that most people would realize shouldn't be subject to this kind of intervention. And I left there and I wrote a paper about the use of aversives. I called Amnesty International because I thought, well, they're the torture people. Where are they in this? And I told them what I saw. They were having their national meeting in Boston, and I told them I wanted to speak at their national meeting. And the head of programming there said, well, what was this place? A juvenile prison? And I said, no, it's, as it was then, a facility for people with autism. And the guy from Amnesty said, oh yeah, well, we don't get involved in that. I know, but why? He said, well, because we're not doctors. We don't know what people like that need. And so I think that kind of sums it up. I've never been able over the next 30 years to get Amnesty interested in this issue. And I think it sums it up in terms of what you were talking about, Ari and Jan, with this otherness, that we allow things to be done to people with disabilities that we would never tolerate for any other population. The UN Special Rapporteur for Torture said it's not done, and it wouldn't be legal to be done against political prisoners or even convicted terrorists. And yet we do it to people with disabilities because we as a society have the ability to separate ourselves from people with disabilities and say, that's them, not us, and we will do things that we would never tolerate for any other disenfranchised population.
We have thoughts on that question from any of our other panelists? Finn, Jennifer?
I think, I think that Nancy is absolutely right about attitudes toward people with disabilities. I first heard about the JRC myself when I was about 19 and starting to get involved in online disability advocacy. That was about 16 years ago. And I remember reading about it and I was horrified. I myself am autistic and went through behavioral treatments as a child. And although they definitely didn't involve shocks or anything like that, they were still focused on suppressing atypical looking behavior. My personal well-being and happiness did not come into, were not part of my personal well-being and happiness were not the goal. My goal was to conform regardless of how I felt. And of course, it didn't work. I was still autistic. I just ended up miserable and had to, recover from that as an adult. And I realize now that the problem with the JRC and similar aversive methods is that they are unjustifiable. So the philosopher T.M. Scanlon wrote a book called What We Owe to Each Other, and he defined moral actions as those that we can reasonably justify to others. And although defenders of the JRC and its aversive methods point to behavioral outcomes, that is not the same thing as justifiability. I don't think anyone would accept this treatment if it were described to them fully. If they told them what it was for, I wouldn't accept it. And the willingness of practitioners to substitute students to literal torture to achieve optimal outcomes, that demonstrates an abdication of moral responsibility. It's a form of medical Machiavellianism in which the ends justify the means, no matter the cost to the victim's human dignity. And so the philosopher Immanuel Kant, on the other hand, he commands us to do better. He says, treat humanity, whether in your own person or the person of any other, never merely as a means to an end, but always at the same time as an end. So people exist as ends in themselves, not just for others' convenience. They're people, we're people. And when we decide to subject people to electric shocks to control their behavior, we are saying that the ends, that is compliance, justify these torturous and inhumane means. And that is not in keeping with any ethical system that actually encourages good behavior. People should do the right thing because it's the right thing, not because they're being shocked into doing it. And being a disabled person is not intrinsically wrong. And so when we use aversive techniques to gain compliance, what we're saying is that people's primary goal is to satisfy others' wishes, not to live fulfilling and complete lives. So are we going to accept people as they are, or are we just going to treat people like tools? And we can and we should do better. So that's what I learned about the JRC.
Jennifer?
Jennifer, so yeah, I can't even remember exactly when I first learned about the JRC. It would have been somewhere around probably 25 years ago when I began my legal career, which was always centered on representing folks with primarily psychiatric disabilities and to some extent intellectual disabilities and other disabilities. And, I think that what happened and continues to happen at JRC really, to me is reflective, has always been reflective of so many other pieces of our service systems of how we kind of treat people with disabilities as if they don't have enough agency themselves, they don't have enough of a voice, or, if they have views or feelings that they're not really worthy of being considered. And that, as long as you have experts on both sides, which you will always have with all of disability advocacy, as long as you have family members on both sides, which you always have in disability issues, it is hard to get past some of these issues. It makes people nervous. What if I'm doing something wrong? What if, what all the disability advocates tell me, isn't right? And what if, some of these doctors or some of these families are right that I'm actually going to destroy somebody's life if, I don't continue doing this. And I think those are the challenges that we, face and have always had to get past in this context and in so many others. And so I see it sort of very much as a piece with so much of disability advocacy. And in my area, because it's people primarily with psychiatric disabilities, it is all about devoicing people. It is all about, labeling people. Once they have a label, then, anything you say, it starts to not matter, right? You have a label of lack of insight, essentially, that is tacked on you and follows you where you go. And even, when people have perfectly valid reasons, maybe it's not even about the extremity, as happens in JRC, of screaming in pain and being tortured, but people saying, I really don't want to do this because it's extremely uncomfortable for me, or it hurts. And that is typically dismissed as that, this person lacks insight, this person is not the person that we listen to, is not the decision maker. And so this is what we're going to do. And so I think it's fascinating and terrifying, and it really is not its own thing. It is very much reflective of so much that we are dealing with in the treatment of people with disabilities writ large.
Jennifer, I want to build on that by sending you another question, if you don't mind. You're in DC and you're very much in the thick of things. I wonder if you can give us an update on the ongoing efforts to try and end the use of contingent electric shock, and where we stand, and what people should be thinking about or doing to try and keep up that fight.
That's a great question. I mean, I think that the litigation has been very interesting. I mean, as you all know, there have been decades and decades of litigation to try to address these practices, both shock and other things that have happened at JRC, BRI, mostly with few results. But I do think that what many of us found really encouraging about the FDA's pursuit of this shock ban is that it seemed like it was going to stick, that it was well reasoned, that it was a good tool, that it perhaps was a better tool than many of the others that we had at our disposal for all those years. It was so thoroughly and extensively supported through research, hearings, and experts. And it was rare to see a proposed rule that looked like that had that much work put into it. And, and yet, really, it went off, the decision from the appeals court went off in a completely different direction. And there was this very legalistic issue about what the FDA's authority is to regulate medical devices. And I mean, to me, I read it, it seemed like a no-brainer that the rule says that they can regulate or prohibit the use of devices, medical devices that they find are unreasonably dangerous, unreasonably unsafe. And they did this based on extensive findings of that it was not safe, that it caused all manner of harms, that it was also largely ineffective, that it did things on a short-term basis, but on a long-term basis, it really did very little. And putting all of that together, they said, we think we can regulate the use of these devices for these purposes, for addressing self-injurious behavior and aggressive behaviors. And then you had this court saying, no, you got to either completely ban the devices or not ban them at all. And this is what we think that the regulation lets you do. And, it's all or nothing. And too bad if, you want to tailor it, because there are things, I mean, there were uses for smoking and other things that, people did want to use these devices for, not the same device, right, as Rotenberg uses, but one of this kind of constellation of electric shock devices. But it was different. And the FDA said that's different because the person themselves holds the controls to the device. They can stop when they think it is too painful. They can control it, and that makes all the difference in the world. And this is, something that we don't want. That is something we want to allow, and that seems perfectly reasonable. But under this regime that was the interpretation of the DC Circuit, that they can't do that. And so right now, there are a couple of options going forward. The Justice Department, many of us asked them to please continue with this litigation, because we thought they were in the right. And there was a dissent. One of the three on the panel of judges dissented. And so they are pursuing it. They did ask the full court to hear it. We don't know what will happen. But either the full court will say, sorry, we're not going to hear it, or the full court will hear it, and then maybe they win, maybe they don't. If we end up with something that is not a win, then there is another avenue, I think, for the FDA to consider, which is a narrower rule, which is just about the device that the Rotenberg Center uses. And it doesn't run into the same problem that this one did about you're regulating it only for certain uses and not for other uses, and you can't do that. And so I think there is a potential avenue there, which may be very fruitful. I am sure that there will be ways to get around that as well, if that's it. But that is looking actually like one of the pretty good strategies that we have going forward.
Thank you, Jennifer. Finn, I want to turn to you. I think you're very aware of the fact that the Judge Rotenberg Center aggressively recruits from families that face various forms of marginalization. Once worked with a family of Russian immigrants that were being aggressively recruited by the JRC after their child was involuntarily committed, and they came to this family and said, well, we have this wonderful facility, we don't use any psychotropic drugs, there's just a small catch. And that's a strategy they use with families across a lot of layers of marginalization. And of course, race is one of them. I wonder if you could speak to that, if you could speak to the racial equity components of this issue, and the ways in which entities like the Judge Rotenberg Center can sometimes try and exploit that marginalization in order to funnel people into their facility.
Oh man, that is a great question, though it is not a great topic, because it's clear that they are taking advantage of systemic racism and a lack of information among some parents who don't have a lot of education or who just came to this country and don't know much about disability. And for example, a lot of Black families do not have, in the Black community, there's often a reluctance to discuss disability. We often don't talk about it. And a lot of Black people do not get diagnosed with autism as children. I was, but this was an unusual case. But in general, we don't. We're more likely to have other diagnoses. And if these are working class families of color, then they're unlikely to have extensive educations. They're unlikely to know what treatments are actually effective, what treatments actually acknowledge their children's dignity. And so the JRC can come in and sell their cruel methods as humane because, oh, we're not going to drug up your kids, we're going to help them. And so these desperate parents who don't have the background information are being taken for a ride. And because society already discredits the voices of people with disabilities. Nobody speaks up about it, or I mean, they do, but nobody listens. As I believe Jennifer mentioned, it's this form of injustice that silences people who are already marginalized. And so because you have these people presenting themselves as experts and who have, I guess, the right level of insight, as opposed to those poor disabled survivors who can't recognize when they're being mistreated, that's what they think. You have these JRC representatives and defenders coming in and saying, hey, we're going to help your kid. And then on top of that, a lot of families of color, because they live in a society that is discriminatory, and because there's so much generational trauma, especially from Black parents, especially with African-American families, there's sometimes an authoritarian streak. I'm not saying that all Black families have an authoritarian streak, not at all, because that would be a form of internalized racism itself. But a lot of these families, because of the way that they were brought up, because they picked up these tendencies from slavery, from Jim Crow, from years and years and years of generational trauma, they think that these aversive ways of raising children are effective and will make sure that they will be safe in a society that discriminates against them. Of course, they're wrong. Of course, that, as I said before, the ends do not justify the means. We are creating generations of traumatized and deeply, traumatized and sad and frustrated and angry people, and using this kind of these authoritarian and punitive methods to justify this. But no, it's just a reflection of that generational trauma where these parents take these methods. And so the JRC fits right into that, where they play on those, that even if it's not conscious, they play on this kind of marginalization. They play on this generational trauma. They play on the idea that to be a good Black person in society, then you have to follow these rules and exhibit blind obedience, even though this tendency toward blind obedience, this tendency toward using punishment and reward morality comes from systemic oppression itself. It comes from the way that slave masters treated enslaved people. It comes from the way that people were treated during Jim Crow, that if you even looked at a white person the wrong way, you could get lynched. So a lot of people will recreate these oppressive dynamics in their house. That's the way I grew up. My parents were extremely authoritarian. It was all about punishment and reward. It was not about morality for its own sake. And so, I mean, fortunately, I was never sent to the JRC, but I can see why the JRC takes advantage of this structural oppression. And I think that the situation may be similar for other ethnic and racial groups that experience discrimination, and immigrants as well. But because I am African-American, that's my experience, and that's what I can talk about.
Thank you so much, Finn. I think that was very powerful. Nancy, I want to turn to you, and I'm hoping you can give us the benefit of your years of experience here. I want to ask you this question, a question that Jan and I kind of alluded to in our discussion, namely that you've got, over the many, many decades in which this took place, you've got some people who saw what was happening and really mobilized to try and stop it. You've got other people who really ended up collaborating with it, who saw this as part and parcel of the larger field of disability service provision. And, it's noteworthy that the Association for Behavioral Analysis International, a major trade association of ABA providers, still permits the JRC to present and act as an exhibitor. And that one point that Jan made in her book is that after the Judge Rotenberg's decision preventing Massachusetts from closing the JRC, the ABA, the Association for Behavioral Analysis, actually gave an award to the parents who acted as plaintiffs in that case, preventing Massachusetts from closing the facility. So I guess my question to you here is, how should we think about those people who have been complicit in what the JRC does? And what, to what extent should they be a focus of advocacy alongside our ongoing efforts with respect to the Judge Rotenberg Center itself? You know, where should we, how should we think about responsibility with respect to the larger fields that the JRC emerges from?
Thanks, Ari. I think there are a couple of myths that are at play and that JRC will promote. Almost every mainstream national organization, disability organization, has taken a position against the use of aversive restraint, unnecessary restraint. But then JRC would have us believe that there are these very few people who are extremely dangerous. And there are people who are extremely dangerous. You know, anybody who's worked in the real world, my background includes a lot of work in the behavioral area, knows that there are people who, without some kind of support, will severely hurt themselves or hurt somebody else. But one of the myths is that the, 240, 260, 280 people who are there now, we never know exactly how many, are the only severely dangerous people in the country. There are people who have very dangerous behaviors in every state who are served by community agencies and who are served humanely and effectively. People always ask, like, how could parents do this? Like, what's wrong with these parents that they send their kid to a place like this? And you've got to understand that, as was already discussed, Ari, when you said they sell it, that you go to a parent. I don't think it's any parent's first, second, or 22nd choice, but it looks like a beautiful place. It is a beautiful place physically. And parents make a tough decision, mostly because they've been failed by the disability system, by the system of services that exist. Once you make a decision to send your child or your adult son or daughter to a place like that, I think you have to convince yourself and the world at large that you did right by your kid. I mean, every parent wants to do right by their kid. And so there's this desire to say, well, but my son or daughter's circumstance, because of the behaviors that my son or daughter exhibits, this is justified. And, if electric shock were used only when somebody were imminently at risk of putting their fist through a plate glass window or hurting themselves or hurting somebody else, my position about it wouldn't change, but I think the discussion would be different. In fact, most, if you look back at the way that shock is used, it's not used when somebody is at imminent risk of hurting themselves or somebody else. It's used for any number of behaviors that are innocuous. I talked about taking your eyes off your work, but not maintaining a neat appearance. Jennifer Masumba talks about, she's a survivor who's quoted in the book, talks about making more than 5 noises in an hour. I mean, there's all kinds of uses that they would say, getting out of your seat before being told to get out of your seat. Well, somebody might get out of their seat and that might be aggressive. Of course, they might get out of their seat and not be aggressive. So, and the other myth is that this is a place for people with autism and other kinds of developmental disabilities, which it was, but now the population is really changing and they recruit mostly people of color from New York City and the boroughs who are in trouble with the law and going to juvenile court. And the population has shifted to people who aren't getting the kind of support they need in their home communities, and school systems are willing to pay to send them out of the city and get them out of their hair. And that more and more is making up the kind of person that there is there now. So I don't think, like as you spoke to, Ari, if we agree that people have behavioral issues that challenge us, because they're frustrated and because they're protesting the crappy lives that our disability system offers most people, we have no problem, here's a person with a disability. Well, we need to put them in a group home. They need to go to a day program where they do some meaningless stuff. We pretend that that's job training, but it's not. I think a lot of the behaviors that we see are people's efforts to gain control over their lives. I think there's no greater human impulse than to be in charge of your own life. And when somebody is protesting and telling us through their behavior that they want to be in charge of their own lives, our system, not just JRC, but the system more broadly, has this tendency to say, oh, here, this person's acting out. They need more structure. We like to call it structure because we don't like to call it restrictiveness. That doesn't sound as good. They need more control. And so you're telling us you want to be in control? Well, we're going to control you even more. Oh, now you've upped the ante and you're really telling us you want to be in control? Well, we'll control you even more. So some of what happens at JRC is kind of a spin-off from what happens in regular everyday programs where we think we know better what's good for people with disabilities than people know for themselves. And that's just never the case.
I think that's a very powerful note. It's a very powerful note. I want to, in closing, give each of our panelists an opportunity to say a few words about where they feel the disability advocacy movement, the disability rights movement needs to go in the future with respect to the JRC and with respect to the lessons the fight against the JRC should leave us in our ongoing work. Jennifer, do you want to go first?
Sure. I thought that Jan raised a really good point at the beginning. Whatever she said was really resonating with me about kind of, as long as we are doing this sort of othering and treating these folks as somehow different, that we are stuck in this problem, and that she said something about really the power of the self-advocacy movement to take us to a different place. I think that's right. I think that's where, my inclinations have been recently in the mental health world. It sort of looks slightly different, I think, than in the IDD, intellectual developmental disabilities world, in that in mental health, people are talking a little less about kind of self-advocacy as a term and more about peers, but basically being in control, being in the driver's seat. It is interesting because I think service systems have started to recognize, not fully enough, but there is emerging, I think, more and more of an understanding of the utility of actually listening to people with disabilities. And I wouldn't say that service systems quite get yet how much people with disabilities have to teach us, but I think that there's been positive experiences and people realize, hey, this actually works, when we listen to people, and we actually try to take the time to understand what people are trying to tell us. And, I think even you see it with things which I wouldn't consider self-advocacy, but like advanced directives or something, that actually, if you give people the opportunity to write out or say in advance, this is what I want, should I become in this position? I don't want somebody else to make these decisions for me. I can tell you this is what I want, and I can tell you why. I don't want this treatment. I've had this treatment before. This is what it does to me. It's not just you lack insight. You're psychotic. You're crazy. Whatever. You shouldn't be listened to. People have very rational and very good reasons for wanting to make certain choices, and it makes it easier for everybody if we can actually follow those choices. And those the key to actually serving people well. And it is a hard leap for service systems to make, that it really haven't functioned that way. You know, we have never functioned in a way that puts people with disabilities truly at the center, even though we do a lot of talking about it. But I think that's really where we need to get. And I think certainly the more that we can thrust into the spotlight, you know, people's stories in a way that it matters to people, I do think it makes a difference. And I'll shut up in a minute, but I just want to use the example of Britney Spears and the guardianship process to say, you know, these are issues that many people in the disability community had been really complaining about for many, many years, and not just complaining, but highlighting that, you know, significant, dramatic rights violations that and problematic things that happen to people. And really, you know, we never move the needle. And then, you know, a celebrity comes and is in this experience, and suddenly, you know, the same media that always thought, oh, well, of course, but this is how it is because these are people with disabilities, and of course they need this, and of course, you know, we couldn't expect people like this to make their own decisions. Suddenly they see it in practice with someone who people kind of know about, and everyone's outraged. And so you know, I mean, it's an anecdote. I don't mean to take it further than it should go, but I do think that it's kind of an example of, you know, when you can get the right people and the right stories out there, that, you know, it is really a key to changing how things work, getting people to understand that it really actually does make sense to pay attention to the people who are at the center of what you're talking about, just like you wouldn't talk about making policy for women by gathering up their husbands and talking to them.
As a case in point, Jennifer Masimba wrote to me in January of 2013. Jennifer is a JRC survivor. Jennifer herself, by the way, just wrote and published a book called Shouting at Leaves that tells her story of her life, including her time at the Judge Rotenberg Center. Advocates had been working on this issue since the beginning of time, but when Jennifer sent her letter, and at first Jennifer sent me the letter saying, I'd like your help to get this story out, but I'd like to remain anonymous. I use her name today because she no longer chooses to be anonymous. She is happy for people to know her story. And a large part of her story is quoted in the book. It wasn't until the FDA and the Department of Justice heard directly from Jennifer that the needle really moved. The whole FDA ban would not have happened without Jennifer and her willingness to tell her story and her ability to tell her story with incredible recall and detail. When I sent that letter, Jennifer's letter, to the Department of Justice and the FDA, both federal agencies wanted to meet with her by phone, and she asked me to be on those calls with her. And, you know, clearly they wanted to establish that she really was a real person. And this wasn't, you know, something that some advocate had written on her behalf or pretending to be her or whatever. This change in population that I spoke about is important because one of the ways that JRC has remained, stays around, is that for many years, the people who were there by virtue of the significance of their disability couldn't tell their own stories. And so they capitalized on the fact that people couldn't come out and say, here's what happened to me. Now we have people who are there and who are leaving. JRC, you know, doesn't always, it's not always their choice that people leave, but people end up leaving and they can tell their stories. And one of the things I'm working on currently is to work with people who have been at JRC and interview them and help them to write their own stories just for their own use, unless they choose to use it otherwise, but to just document this history so that, like Jennifer has done with her story, we have more and more people speaking out on their own behalf, because that is really what has influenced change and what will continue to influence change. No one who hasn't been there, who hasn't experienced it. One of the things I said to Jennifer at one point was that, if we get the FDA to ban electric shock, they're going to go back to some of the other awful things they used to do. They used to have staff grow their fingernails long enough so they could give rolling pinches and remove chunks of flesh. They had giant rubber spatulas manufactured so they could spank people with these rubber spatulas. They used taste aversives like jalapeno pepper to the mouth. And they used this visual screening helmet where you were in the dark and there was white noise in your ears and water shushing into your face. So I said to Jennifer, if they eliminate the use, and of course they use food deprivation and they use restraint as punishment. So I said to Jennifer, if we eliminate electric shock, they're going to go back and still use some of this. It's still going to be an environment of control. You can't have an environment of total control and then lay on top of that some kind of positive reinforcement, because the environment itself is aversive. Jennifer said none of that, electric shock is more horrifying than any of that. But, we just should remember that the environment itself is always going to be aversive when there's that much control.
Thank you so much, Nancy. Finn, you have the final word.
Okay, I'll try to. Jennifer and Nancy were a tough act to follow, but anyway. So as disability advocates, I think that it's important, again, to tell stories just as Jennifer Masumba did. She was incredibly brave to do that, especially as a disabled woman of color who experienced, the horrors of the JRC. I think that it's important for her and for other people to tell those stories, because legislators and we can show all the facts and dates we can, but ultimately what this is about is people. And we are more likely to respond to real stories that we can connect to. They're more likely to respond when they can see our faces, hear our voices. And the JRC tried to prevent us from doing that, tried to prevent people from doing that by silencing them, by basically having this reign of terror over these marginalized people who experience discrimination for God knows how many reasons. So it's important to liberate people, to allow them to tell their stories. It's also important to work with different organizations that may also be interested in stopping this injustice. For example, working with racial justice organizations, because people of color are so disproportionately affected by the policies of the JRC. Working with professionals who are familiar with generational trauma and how that plays into the aversive environment that the JRC uses and promotes and kind of capitalizes on. And it's also important for us to think about ethics and morals in medical practice and how the ends do not justify the means, because these are superficial ends. Oh, they look as though they're behaving, they look as though they care, they look as though they're compliant, but inside they are miserable. They are miserable. They don't feel an imperative to behave well or to stop doing what they're doing because they want to. They're doing it because they're afraid. And you cannot use fear as a way to inculcate moral or good behavior into people without these kinds of deleterious consequences. It's dangerous and it's downright evil. And we need to remember what we owe to each other as community members, and each other includes people with disabilities. If we have an ethical model that does not include everyone, then it's useless. It's worthless, because we are not engaging the entire community. And, I believe Jennifer, you're the one who talked about lack of insight. This idea that some people don't have insight and therefore do not have the right to speak up, that is extremely harmful, because there are a lot of people who can't speak for themselves but still deserve fair treatment regardless. They are still people. It doesn't, even if they can't tell their story, that does not mean that they do not feel pain. You know, what group of people also lacks insight? Children. Children. And we have moved away from, we're still in the process of doing it. There are still families that do this to kids, but we are moving away from using corporal punishment and aversive methods to reinforce good behavior in children. And children don't understand everything that's going on around them because they're too young. But we don't do this to children. And this isn't even limited to humans, animals. We wouldn't do this to it. We wouldn't use these aversive methods on dogs. Dogs don't have insight, but does that mean we mistreat dogs? No. So if we understand that we have moral obligations to children without disabilities and other animals, not even humans, but other animals, then we should have the same concern for people with disabilities of any age.
Thank you, Finn. I think that's really powerful. I want to thank all of our panelists. You've done an extraordinary job. And I also want to thank Jan for this extraordinary book. Without further ado, I will hand things over to Sue to wrap things up. But thank you all so much for joining us. Sue?
I just want to add my thanks to everybody, to Jan for writing the book and being so articulate and powerful, you know, with the stories she told and the passages she read and the discussion with Ari, and Ari for being a terrific moderator, and to our panelists, Nancy and Jennifer, and Finn for a very spirited discussion, which really leaves us pointers of where are we going to go next. I mean, it's a developing story. It's still not settled. There are many battles still to be made, and I think that this conversation was enlightening, and you know, hopefully we'll all stay engaged. So thank you. Also to thank the Lurie Institute again, and to say that this session has been recorded and will be sent to everybody. A link will be sent to everybody to access this recording. So thank you, and I hope you enjoy the book and the rest of the afternoon. Thanks. Bye.
You.
Everyone.